Well, hello and welcome back. It feels like forever and a day since I've been away. It's been Christmas and New Year, and I've promised you an NDIS video for months, and it's taken me a while to get it together, but I finally got there. Um, so, with no further ado, let's go. So, the NDIS. What can I say? Applying can be a daunting task, and more often than not, it's an administrative nightmare. Now, my aim in sharing the information in this video and on this channel is to hopefully help someone else make the application process just a little bit easier. So please like and subscribe to the channel, share the love, get the message out there, ring that notification bell, and you'll be updated whenever I post another video. And I'm intending to go and do some live streaming soon, so I haven't worked out a schedule or a routine yet, so ring that bell and you'll be notified as soon as I organise a live stream, hopefully with some question and answers. But looking forward to it. So, moving along. Now, I'm going to break down, or try to, the process from the beginning to the end. So, you've prepared your application. It's called an Access Request Form, or ARF, and the NDIS have went, no, no soup for you. Let me just move myself over. Can't move myself. All right. So they've said no. Surprise, surprise. So in this video, we're going to go through all the legislative tools that they use and are bound by and how they are applied. We're going to go through the assessment and the intake process. We're going to address their functional approach that they use instead of a diagnostic approach. We're going to stress the importance of Section 42 1C of the NDIS Act. Now, anyone who has previously applied to the NDIS knows exactly what I'm talking about here. Then we're going to go to the internal review process, the external review application process, the role of the Administrative Appeals Tribunal and its limited scope, and then finally on to the final court hearing and decision from the tribunal, and then what your options are going forward from there. So they claim that they are there to promote and support people with disability and provide all these necessary services to support people with disabilities and their carers. But the journey between applying for their support and actually getting it is an ocean in between. The eligibility criteria for a start is just scrutinised. You've got to meet every aspect of the eligibility criteria. Now, I get that there is a need to meet eligibility criteria, but this pushes it to another level. And not only do you need to prove all of the aspects that your disability meets the criteria, you need to do that for every diagnosis that you submit. So you're better off choosing, if you've got multiple and complex issues like myself, pick the biggest one and meet the criteria for that primary diagnosis and focus on that with all of your evidence, and exhaust every option and then some, even to the point of naming the specialist that you go to, because I got knocked back because my rheumatologist had reviewed my CT scans, and he hadn't documented that anywhere. So in their decision, it had said that there was no specialist review of the CTs. Okay. So you need to prove that you are left with a significant, remember that word, significant functional impairment caused by your diagnosis. Now, even when you do that, there's no guarantees. And it does sound like hard work, because it is. It took me 3 months to compile my last access request form. It was 56 pages in length, and I submitted it, and they used the wrong one. So you're not dealing with the brightest tools in the shed. From personal experience, it's painstaking, time-consuming, and exhausting, especially when you have chronic disease to live with as well, and fatigue being a major component of that. They, yeah, they're just as an excessive amount of red tape and barriers to overcome, and it had me questioning: are they here to help or hinder me, really? So, the main legislative tool that they use is the NDIS Act. The NDIS Act 2013. Now, that's the national legislation regulating the criteria that they have to adhere to, and we have to adhere to require and permit access to the NDIS and their services. So I highly recommend that you familiarise yourself with it, download it, print it, highlight it, do whatever you need to do to make it like it's second nature, and use it like a checklist, especially sections 21 to 25 of the Act. They deal particularly with the disability requirements that you need to meet for access. They also then refer to the NDIS's rules for becoming a participant, and particularly 5.8. I would download and print that off as well and familiarise yourself with it, because they are looking for specific wording. So when you're asking your specialists or your GPs for evidence, I would do up a template and list pretty much what you want them to fill in, and have them repeat significant functional impairment, permanent, chronic. Just overload them with the words that they're looking for. The only issue that I had was that the word significant is open to interpretation by the NDIS, and they use it at their discretion. I got told I had substantially reduced functional impairment, but not significant. So make sure you get the wording right. It's really important. Okay, next section. Let's go back one. All right, so we've done. So the NDIS are function based. They don't care how many diagnoses you have. They are looking for how your impairment causes you to have a significantly reduced capacity to function. All right, so you need to not only prove that you've got a diagnosis that's been diagnosed by the appropriate person in the appropriate way, and that you have met all of the criteria as far as treatments have gone and addressed all of every possible treatment known to man, and you are still left with a significant functional impact. That's what they're looking for, and this is actually it shows an extract from part of the rules in the NDIS rules for becoming a participant. So it says what the legislative scheme focuses on is not the name of a person's disability, nor the diagnosis given to a person, but rather what are the impairments experienced by a person which may require supports so that the person can participate in all aspects of personal and community life. It is the impairment which the scheme contemplates may affect, and I can't read the bottom of it, the quality of life, basically. Now, sounds good, and in theory, it's great, but do they necessarily come full? Do they necessarily come through with the goods? So, one of the biggest obstacles I found, and the hardest to accept, was the actual intake process itself. Now, I put 3 months of blood, sweat, and tears into my application and had a table of contents, had references, had it completely, I made it as easy to follow and as accurate as possible. I had addressed everything through the NDIS Act and itemised it for what I thought was idiot proof. I was wrong. But as I said, they submitted the wrong application, the one from the previous year, which I and hadn't even looked at the 56 pages that I'd spent all this time preparing. Now, the main issue is that the assessors, the people on the front line that get your assessment or your application, they're not medical professionals. They have no medical training. They have no medical experience. They don't understand the scope of your medical conditions, how it progresses, what your prognosis could be, side effects of any procedures or medications. They have no idea. They basically need to be spoon fed, and that just blew my mind. How can you have someone that is assessing your impairments for a disability without any training, knowledge, or experience? It gave them it limited their ability to use, a bit of common sense latitude to the assessment. There was none of that. None. So once you've submitted your application, the people on the front line, the intake assessors, get to work, apparently assessing. But as I said, they're not medical professionals. So the NDIS had to come up with a solution on how to get past this hurdle. So what they did was they created cheat sheets. So if you actually look up on the NDIS website somewhere, I can't remember where I found it, but there was 3 lists, and they're lists that are basically ranked in how severe your functional impact is. So list 1 basically is the highest, and if your diagnosis is on that list, then it more than likely will meet the criteria and you're more than likely to get in. They'll tick that box and go, sweet, you're in, done. List 2 is just about the same, but they will ask you for a little bit more information. So that's their next cheat sheet. And list 3 is the same again, level down, but you'll probably be asked to either have another assessment by one of their allied health team or for further information, just to really lather the bread, basically, to justify their decision. Now, during my research, I found a site online called the Victorian Council of Social Services, and they have done an in-depth research and analysis of the systemic inadequacies of the NDIS's policies and procedures. and it actually reaffirmed the issues that I had had. It was basically like they'd been inside my brain and went, "Oh my god, they're having the same issues that I am." That they've predicted what the problems were going to be, or the problems that I encountered straight off the bat. So it's worth a read if you fancy looking into that. It does address all of the issues, and it gives you a better understanding of how the NDIS works. Or doesn't, for want of a better word. So now, the definition of substantially reduced functional impact is extremely important. So, to you need to become a participant, you need to prove that you are substantially impacted in one of the following areas: in communication, social interaction or isolation, learning, mobility, self care, or self management. Not all, just one of them. So, your disability or your impairment needs to substantially reduce your functioning in one of these areas. So, I picked my top three and focused on those. You can pick whichever ones um, work most appropriate for you. You can pick just one and focus on getting as much evidence towards that one as you possibly can, to prove the significance and the substantial amount of impairment. Basically, the more evidence you have, the greater the impact. So, yeah, keep it as simple and as focused as you can. And as I said, their interpretation of the word significant is it's one of the biggest reasons for the internal and external appeals process. Basically, I got onto the tribunal's website, and I wasn't the only one that had administrative errors right throughout their application, and I've just put in a little extract there that it shows. I screenshotted it straight off their website. Some other poor applicant having the same issues, so it's not a one-off, basically. So, all right, you've been told by the NDIS, no, can't come in. Sorry. So you then have the right, if you feel that you are entitled to access, you have the right then to request what's called an internal review, or an S100. You can download that form from their website, but once you get your letter of denial, they will actually go right through and describe in detail why they made their decision, how they made it, what documentation they used in their assessment, and then detail your options on how to move forward with an internal review. And it will be done by a different NDIS assessor, but they will also be unqualified. Okay, so all right, they've done their internal review, and they have followed the same guidelines, and lo and behold, you get another letter back saying, sorry, no. Yeah, the answer's no. And actually, in that report that I was referring back to, um, they actually mentioned that some of the issues with the internal review process was employees feeling that they needed to toe the line to maintain their employment. So there's a lot of baggage surrounding the whole process. Anyway, so they've said no again. So now you have the same thing occurs. You get your massive letter of decision saying ba-bong, and it will outline in detail why you don't meet the criteria, how they made the decision, and the documentation they've used. Now, pay attention, read what documents they actually used to make that decision, because that was the only way I found out that they'd used the wrong application. Otherwise, I'd been none the wiser. So make sure they've used the right documents. So they will then, again, at the end of their decision letter, give you all of the information on how to go about applying for an external review process, which involves applying to the Administrative Appeals Tribunal. Yeah. So their role basically is supposed to be an external, unbiased second opinion on the NDIS's decision. But they are limited to only matters of law within the NDIS Act itself. So if the issue that you are claiming that, they've denied you access because they've got their facts wrong, the tribunal will not even contemplate, bother looking at that. That is not, the law of fact is not their problem. They deal with just the law within the Act itself. So if the NDIS didn't use Rule 24(1)(e), then the tribunal would consider looking at it, because that's a matter of law. But the facts don't matter, apparently. I've actually just had my final court hearing with the tribunal, who blatantly disregarded my witness testimonies, and their decision in writing was completely the opposite of what my witness had said. And when I asked the tribunal to review that decision, because the facts were completely wrong and I had the evidence, I've got the video of the hearing, they told me that they would not review their decision, that I had to go on to the next level, and that the facts, they followed the law, and the facts are basically, they're not interested. So I filed a complaint with the tribunal with regards to them not addressing the fact that their facts were wrong. And I got a letter back today saying, we can't help you. The where's my letter? The member can only be reviewed on matters of law, not fact. And so we can't help you. So why have a complaints process in the first place? And then they went on to say that I could take it further, but the federal court would only deal in matters of law as well. So it basically gives the NDIS free rein to completely stuff up your application and muck you around for years in the process and get away with it, because no one will address it. Unbelievable. So they use this to their advantage. Don't start me. So the final hearing it was fairly stressful, because I was self-representing. I had applied to multiple agencies for advocacy, and they were either too busy and overloaded with other tribunal cases with the NDIS, or I wasn't in their catchment area, or whatever. So self-representing, I'd studied the legislation inside out, back to front by this stage, so I was more than happy to do that. It was done via Zoom, and it pretty much follows the courtroom procedures. So you have to subpoena witnesses, and the whole shebang, basically. But the tribunal was actually quite helpful. They are aware of the difficulties faced by people representing themselves, and they were very good at providing guidance, evidence, and instructions to me on the processes needed to go through, the steps to go through, basically, to get to the hearing. Right. So the hearing will progress exactly like a court case. So you have to have your opening statements, and the applicant goes first, which is you. Then you have your witness testimonies, and then you get to directly examine your witness, and then the defence gets to cross-examine, and then you get the chance as to rebut anything. So keep a pen and paper on you, make notes of any questions or issues that the defence have brought up that you want clarifying, and you get a chance then to re-question your witness and their witness should you need to. So the witness testimonies, firstly the applicant's witnesses, then the defence witnesses if they call any, and you get a chance to cross-examine their witnesses as well, and then you both make your closing arguments and statements, and then it's left to the tribunal member to make their decision. There is no limit to the witnesses that you call, and the tribunal will be in contact with you depending on how many witnesses you subpoena. They will ask you how many, who they are, what their contact details are so that they can link them in, and then they will allocate a certain amount of time, so whether it be 1 day, 2 days, 3 days, accordingly. So they're quite good at keeping you up to date and knowing what to do and where to go. So when I presented at my Zoom hearing, I was met with the lovely gentleman from the tribunal who was coordinating the call between the parties and the member. So I entered the Zoom call, and there was the tribunal member there who was the one making the decisions, and there were 3 NDIS legal representatives. 3, not 1, 3, against me. I don't understand. Why would you fight so hard to prevent access when you are supposed to be an institution that is there to help people? 3 legal representatives. They had to pay 3 for 2 days to stop me from getting access. Now that doesn't fill me full of confidence. I'm sorry. So your options from here. If the tribunal, as they have in my case, say no, your option is then to apply to the Federal Circuit Court or the Family Court, whichever is necessary. The tribunal will also then send you a massive letter describing exactly why they made the decision and what law they based it on, and case laws and prior prior information, which sections of the Act. They will detail it in complete. And yeah, I think it was 75 pages. But they also make a point of telling you that if you apply to the federal court for a review of the tribunal's decision, that you could be liable to pay the costs should you lose. But I actually went on and had a look. What they failed to mention is that, it's an assumption I make, but I see, in my case, I'm a disability pensioner. So pension concession card holders are exempt from fees. So just double check in your own state or territory or online if you should choose to take that step further. Your option 2 is start all over again. And I'm just about to try and weigh those 2 options up at the moment. That's where I'm at, the crossroads. But if you're over 65, there is a third option. And that's my biggest issue. I am in limbo. I'm in the middle. I need extra services that my local service provider is unable to fund and provide for me. So I have then further injured myself because I'm not getting the adequate support that I'm supposed to be getting. And so I'm having to do things that I'm not supposed to be doing, and it has caused me further injury now, which has further caused me further impairment, which goes against their whole section about early interventions and the rest of it. So, being 52, don't tell anyone, there is very little out there. The NDIS was created to take over from the local area coordinators for providing supports for people with disability. And so all their funding was pretty much transferred to the NDIS. So your options are you're 65 or you're on the NDIS. So I'm not 65 yet. So I will address this one. So if you're over 65, you do have another option. It's called My Aged Care. It's easily Googled. Just Google My Aged Care online. And they will come out and do what's called an aged care assessment, or an ACAS. They come out to your own home. They will assess you from top to toe, front to back, back to front. They'll assess your home. They will ask you how you cope, whether you have a carer, the whole thing. Pretty much like an occupational therapy assessment. But they will then put together, give you a score rating on the level of assistance that you need, and assign a package of care basically that meets your needs. Now that aged care package has a dollar figure attached to it, and you get to choose which provider, who you want, and you've got basically that amount of money allocated against your name to use for whatever services that you should choose or want for the year. And if you have a carer and they're over 65, they can apply too. So you can both have an aged care package in place in the same home, doubling the amount of services that you are actually entitled to. So that brings us to the end. I hope that's been informative to you. It's certainly been a long time in the making, and I have lost complete faith in the disability system at the moment, and yeah, I don't know where to go from here, but can only really go up, I suppose. So enjoy, and don't forget to like, subscribe, share the love, get this word out there, and hopefully more people can access some of the support services that they need. And until next time, Diva out.